Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer program, and here you are on our last and final installment on our Bill of Rights program, the 10th Amendment. The Bill of Rights program has allowed us to walk through the first 10 amendments to the United States Constitution and explore each of them in 1 hour. It's a chance for you to revisit what you learned in law school, or maybe you didn't learn in law school, what you did on the bar or didn't, and really learn everything there is to know in 1 hour about in the current state of the law about all of the amendments. This brings us today to the 10th Amendment. But the Curious Lawyer program is broader than just the Bill of Rights program. If you watch our other programs, you will see that it's an opportunity to look at very, very different areas of the law, off the beaten path, fun, interesting, educational, entertaining areas of the law, and then bring them into your practice. It's a low stress, fun way to get your CLE. So you can do dog law, CIA law, presidential pardon law, the law of the Secret Service, all manner of fun, interesting areas of the law, even down to exploring copyright law through listening and exploring the music of U2. But today, this brings us back to the Bill of Rights program and the 10th Amendment. So let's get going on our 10th Amendment program by looking, of course, at the 10th Amendment. You see it here on the screen. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Profoundly short and simple set of words, yet perhaps in some sense the most important structural systemic statement of the balance of relations between the federal and state government in our constitutional system. Let's start with the battle scene of federalism with Justice O'Connor, and I'm going to have you watch here a short clip of Justice O'Connor speaking while in the United Kingdom to British lawyers and judges about our very, very unique federalism system, and this battle scene of federalism that plays out fundamentally revolves around structurally many portions of the Constitution, of course, but for purposes of the Bill of Rights, the 10th Amendment is central to it. So let's watch this.
But the framers did not think it would be enough simply to place state hands on the central tiller. The framers instead provided that the central government would be one of limited, enumerated powers, with the states retaining those powers that were not delegated upward. At the same time, the Constitution forbade the states from exercising certain powers that would rest in the central government alone. These principles are the primary fulcrum on which the ultimate balance between state authority and national power rests in my country. The limitation of the central government's authority is inherent in our constitutional design. The 10th Amendment to our Constitution, ratified in 1791, reinforces this design by stating that famous truism, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." The framers of our Constitution then established dual spheres of sovereignty, allowing the central government to act directly on individuals in some fields of activity, while preserving the sovereignty of the states acting within their own territorial boundaries. Today's central government certainly does not resemble the limited enterprise that the framers of our Constitution envisioned. While some of the expansion is a result of formal constitutional amendments, our country's response to technological and social change accounts for the lion's share of the growth of central power. The framers could not have foreseen our world of technological sophistication and mass communication. They could not have known the internet, the 747, or biotech corn, any more than they could have envisioned cable television, cloning, or the splitting of the atom. And that is to say nothing of Starbucks, of Napster, or the weakest link. chiefly through Congress's exercise of its powers under the Commerce and Spending Clauses, aided by broad judicial interpretations. The sphere of federal activity in my country has greatly expanded.
Well, there you saw that fantastic sort of snippet of Justice O'Connor's speech, and you can watch the whole of her speech if you go onto that link on Google and where you find it, and you can watch it. It really is a great program to listen to. But what this brings us today to, of course, is what issues are we going to address? How are we going to explore and understand and contextualize the 10th Amendment? So the issues we're addressing are going to include the historical scope and rationale, the purpose, the goal. What is the 10th Amendment? What is it doing? How is it functioning, and what is it meant to function as? We're going to look then at the nature of it. Is it a substantive provision, or is it more of sort of an interpretive tool or almost a declaratory statement about the nature of the relationship between the federal and state systems? We're going to look at many Supreme Court interpretations of this sort of federalism balance over time, many cases from the Supreme Court where we see this shifting nature of the power going to the federal government, going back to the states, all of which is revolving around and often citing and referring to the importance of the 10th Amendment. And we're even going to end with a fascinating little sidebar, really, on pandemics and the 10th Amendment and how the recent experience that we as a nation have had during the COVID pandemic really has sort of brought to the forefront the 10th Amendment, which we never really talk about much. So sit back, make your cocktail, get ready, because in the next hour you will listen to, learn, and explore the whole history of the 10th Amendment. And at your next cocktail party, when someone asks you what the 10th Amendment is about, you will now be able to answer that question. Let's start with a historical context. Of course, the original Constitution did not have a Bill of Rights. And so there was a sort of debate and discussion between the Federalists and the Anti-Federalists about whether we should have a Bill of Rights or not. Here you see the quote from the Federalist Papers, number 64. Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given in the Constitution by which restrictions may be imposed? And so on this view, in other words, if the act of including a Bill of Rights could actually be dangerous because it could be misunderstood to imply that the national government had powers beyond those enumerated. And so this question is the question that was being debated back and forth. If we start enumerating rights and powers, does that imply others exist, and what are we going to do with it? Now, this was ultimately rejected by the majority, and so a Bill of Rights was added. And the 10th Amendment was then added fundamentally to assuage the concerns that people had that the act of listing rights implied that perhaps there were more beyond just the listed ones. And so you see this in Hamilton's Federalist Paper number 32, where he notes that the 10th Amendment simply clarifies that which was already there, and it didn't introduce anything new substantively. In other words, it was simply a marker designed to make clear that the relationship is what it is between the two, and there's nothing that we've done that's altered it beyond what we've said. Now, this idea later gets explained by the Supreme Court of the United States that the 10th Amendment served to, quote, allay fears that the new national government might seek to exercise powers not granted, and that the states might not be able to exercise fully their reserved powers. That comes from U.S. versus Darby, a case we'll talk about shortly. And so fundamentally, what's remarkable about the 10th Amendment is that it really is the main provision in the entirety of the Constitution that in such an express manner recognizes federalism, really, and federalism concepts that are a part of our constitutional system, as opposed to looking at provisions in the Constitution that sort of grant express powers to the federal government by which we can say, that is a recognition that the national government has certain powers, and the act of saying it means that the states impliedly can then have powers that are not given to the federal government. Those arguments come from just interpreting the document and making structural arguments about it, but they don't actually textually say it, whereas the 10th Amendment really is the main textual provision of the Constitution that actually speaks about federalism. Now let's take a look at one of the earliest federalism cases, Hilton versus the United States, 3 U.S. 171 in 1796. And what's fascinating about this case is that Alexander Hamilton argued the appeal, trying to defend the federal tax. And so here's what happened. Congress in 1794, very shortly after the country's formed, of course, it enacts a tax. And it was a tax of $16 on every carriage owned by an individual or business. This immediately, of course, prompted litigation. Who knew? 200 years later, is it any different? In any event, the wealthy carriage owner, Mr. Hilton, I don't think any relation to the modern Hotel Hilton family, in any event, he sued claiming the tax is unlawful. And so the fundamental question that was put to the Supreme Court is, is this carriage tax a direct tax, which under the Constitution would then require apportionment among the states? And the court ultimately concluded that the carriage tax was not a direct tax, and therefore it didn't violate the Constitution's requirement that direct taxes be apportioned among the states. And what the court reasoned is that direct taxes didn't include taxes on the possession of goods. And so here's the quote. It was, however, obviously the intention of the framers of the Constitution that Congress should possess full power over every species of taxable property except exports. That's at page 176. This is a profoundly important federalism decision. Obviously, it comes before McCulloch versus Maryland, which we'll talk about, which is the seminal case in this space, as we all know from our law school days. But in many ways, Hilton is just a precursor to it, a profoundly important federalism decision in terms of asserting that this power that the federal government had over taxation extended beyond perhaps the express reading of the Constitution and had penumbras and bubbles to it, in other words. Now, watch this short video here from the Constitutional Center, because this helps us frame federalism, the 10th Amendment, Hamilton and Jefferson's sort of opposing positions of federalism and anti-federalism. And also what's fascinating about the video clip is it takes you actually into the very case that we're talking about, Hilton, with Alexander Hamilton arguing to defend it. So let's watch.
In theory, Jefferson was a strict constructionist. He really did focus on the text, but the text is misleading. I believe that he thought that all residual power was in the states. He was, as it were, as we might say today, a 10th Amendment person. And if the power wasn't explicitly granted to the federal government, but see how he actually governed with Louisiana, then the federal government should not exercise such a power. From the beginning, Hamilton focused on convenience as his definition of necessary and proper. And this is even before the Bank Memo. And he made that argument again in the only federal case that he argued, the appeal to the Supreme Court in Hilton versus the United States about a carriage tax that he drafted in his last year as Treasury Secretary in mid-94 to help raise money for a possible war. Would it be with France or with Britain? It was unclear. And then he retired 6 months later from the Treasury. He started practice, was drafted back to argue in the Supreme Court defending the carriage tax as an indirect as opposed to a direct tax. And he looked at the language of the Constitution and he said, direct tax, does that have any legal technical meaning? We have his briefs. He said, none, exclamation point. It's a term of art only in a compromised way, which is Patterson, Justice Patterson makes it clear. He was there. This was about slavery. This was about preventing the federal government from taxing enslaved persons as persons. That a capitation tax, including a tax on slaves, would be spread across the entire nation and not burden those states that were heavily had relied on enslaved labor. And Hamilton basically says the only direct taxes we have are land and people. Everything else is an indirect tax. And this is one great example of his empowering interpretation of the Constitution as opposed to his tightening or limiting interpretation of the Constitution. Because in the same case, you have John Taylor of Caroline, who goes on to be a famous state rights advocate, channeling Jefferson, arguing that pretty much every tax is a direct tax and ought to be spread around the country. And he did that deliberately so that his argument would have disabled Congress from Taxing carriages. Some states had a lot of carriages, some had none. If you spread it out, the congressman from the states with no carriages would never endorse a carriage tax. This was disabling. All taxation should be, or most taxation should be, at the state level. And in that case, you can really see a wonderful and somewhat obscure, that people don't know it, a clash between the Jeffersonian interpretation and the Hamiltonian interpretation of federal power.
So there you have it. It's a very, very early decision that fundamentally finds the scope of the congressional tax power within more broadly defined enumerated powers. And this fundamentally went to Hamilton's fundamental belief in terms of the battle going on at the founding of the Republic, that there were implied powers that necessarily also exist, such as in, of course, the Bank of the United States case that comes in McCulloch versus Maryland. And here for the carriage tax, fundamentally his argument was that it's unworkable to apportion the tax in some way, and so it shouldn't be subject to the apportionment idea, and it really falls within the broader scope of congressional indirect broad taxing powers. And that is a win for the federalism idea in terms of on the balance of the national government, the central government having power, perhaps more power than Jefferson would have liked vis-a-vis the states. And so this is a sort of perhaps the earliest federalism decision from the Supreme Court, where we see the federal government winning. Let's go back, though, briefly to the 10th Amendment, because one of the fascinating issues is that the word expressly is not in there. And of course, we all draft settlement agreements, transactional documents, agreements all the time, where we talk about, including rights and not including rights, waiving things expressly and not expressly waiving. And one of the fundamentally fascinating issues is that everyone agreed during the drafting of the 10th Amendment that the word expressly would not be put before the word delegated. And so this actually becomes very important, because what it shows is that the 10th Amendment then structurally is almost really not a yardstick or a measuring stick to identify whether a power is granted or not. And so this absence of the word expressly, as we can obviously imagine for legal arguments as lawyers, it has a lot of ramifications later for what the scope of federal powers would be and how much broader that scope of potential federal powers could be by omission of the word expressly. So now let's get to the Supreme Court and some of the early interpretations in this federalism battle and dealing with the 10th Amendment. And this brings us to McCulloch versus Maryland, 1819, probably the most important case in American history, as we learn in law school at least, in terms of establishing judicial review and the federalism balance. And here we have Chief Justice Marshall addressing the National Bank and also addressing a Maryland tax that had been placed by Maryland law on all non-Maryland bank chartered notes. And at the time, the only non-Maryland bank chartered notes in circulation in Maryland were national bank notes. So it was in essence a state tax on the federal government. And so this put two massive issues before the Supreme Court, one being whether the national bank could exist, whether it was constitutional or not. And this, of course, as you all remember, turns on whether it was within the necessary and proper clause of the Constitution as sort of being something that the federal government could do to, as necessary and proper to fulfill other powers, or whether it went too far and this should be only for the states. And so here we have what Chief Justice Marshall said. Even the 10th Amendment, which was framed for the purpose of quieting the excessive jealousies which had been excited, omits the word expressly and declares only that the powers not delegated to the United States nor prohibited to the states are reserved to the states or to the people, thus leaving the question whether the particular power which may become the subject of contest has been delegated to the one government or prohibited to the other to depend on a fair construction of the whole instrument. That is very, very important language, a fair construction of the whole instrument. In other words, we have a document which is open to argument, and we've got a much broader terrain for which to argue for federal power. The men who drew and adopted this amendment had experienced the embarrassments resulting from the insertion of this word in the Articles of Confederation and probably omitted it to avoid those embarrassments. And so the fundamental point here is that we end up not only with an expansive and then interpretation of the necessary and proper clause to allow it to have breathing room to justify the national bank, And that necessary and proper clause could be read in such an expansive way because the 10th Amendment couldn't be used as a substantive bulwark against it. And so the tax and spending power included the power to make a bank. This starts obviously establishing the expansive scope of federal power. And of course, in the same opinion of profound importance, the state of Maryland could not tax the federal bank in light of the supremacy clause and the supremacy of federal law over state law. And so this is obviously, as scholars say, the most important federalism decision perhaps, or, the original federalism decision in our history. And it's really the key federalism moment. But I would certainly urge to you that I think the Hilton case we saw was another key federalism moment that had also already started us on the path of establishing not only judicial review and, establishing the supremacy of federal law, but at least also establishing the power of interpreting the Constitution in terms of the breadth of the domain of the federal government. These really take us to the early era of America, and these are the key federalism decisions. And this is the first time now we see expressly the 10th Amendment being used to show that it doesn't act in some substantive manner. And this is what's particularly important about it, because it doesn't provide substantive checks and balances, in other words, and it becomes a bit of a statement of obviousness or a truism, as later cases will now show us as we see. And so we can now look at cases getting us up until really the 1930s. And so this continues with a World War I era case, Hamilton versus Kentucky Distilleries at 251 U.S. 146 in 1919. And this dealt with the Wartime Prohibition Act that was passed that made it illegal to sell, for beverage purposes, distilled spirits, and it granted a limited time to dispose of bonded liquors in distilleries. Well, the Kentucky Distillery wasn't happy, so it sued, saying this violated my property rights. I own property. You can't just take my property. And if you're going to, as this applies to any sort of limitation post-war, because the act is based on this sort of idea of limited war powers role of Congress. And here's what the Supreme Court held: that the United States lacks the police power and that this was reserved to the states by the 10th Amendment is true. And so what the court made clear is that the 10th Amendment definitely reserves to the states general police power. But it is nonetheless true that when the United States exerts any of the powers conferred upon it by the Constitution, and in this case it was the War Powers Act, war powers from the federal government under the Constitution, then no valid objection can be based upon the fact that such exercise may attended by the same incidents which attend the exercise by a state of its police power, or that it may tend to accomplish a similar purpose. And so here we have another federal decision from the Supreme Court upholding the supremacy of really federal law and not allowing the 10th Amendment to function as a check on the reach of the Federal Wartime Act and the Act of Congress. This now brings us to the New Deal era, whereas we all remember, of course, that the early New Deal cases were struck down. President Roosevelt threatened to pack the court, and then suddenly the Supreme Court had a change of heart. And as they say, it was a change in time that saved the nine, or some such aphorism is given. But nonetheless, one of those post-change in time that saved the nine cases is United States versus Darby. And this is an early 10th Amendment case in the post-New Deal era from 1941. And here, as you can see, we have Congress adopts the Fair Labor Standards Act of 1938 that required minimum wages and had maximum hours for employees engaged in the production of goods that touch interstate commerce. And here, a general statement from the case in terms of the operating regulation is that the motive and purpose of the present regulation are plainly to make effective the congressional conception of public policy that interstate commerce should not be made the instrument of competition in the distribution of goods produced under substandard labor conditions, which competition is injurious to the commerce and to the states from and to which the commerce flows. The motive and purpose of a regulation of interstate commerce are matters for the legislative judgment upon the exercise of which the Constitution places no restriction and over which the courts are given no control. And so what the court then held is that in looking at the Fair Labor Standards Act is that there was no 10th Amendment violation, that the act didn't unfairly abridge states' rights and tread into state territory. And so here's what's particularly true in terms of the court's interpretation and definition in terms of how it ascribes meaning to the 10th Amendment. The amendment states but a truism that all is retained which has not been surrendered. There is nothing in the history of its adoption to suggest that it was more than declaratory of the relationship between the national and state governments as it had been established by the Constitution before the amendment, or that its purpose was other than to allay fears that the new national government might seek to exercise powers not granted, and that the states might not be able to exercise fully their reserve powers. From the beginning, and for many years, the amendment has been construed as not depriving the national government of authority to resort to all means for the exercise of a granted power, which are appropriate and plainly adapted to the permitted act. And so this is a very, very critical decision from the Supreme Court, which has been followed to this day, that consistently really says that the amendment is a truism. And the moment we look at the 10th Amendment and say that it's a truism that simply is declaratory as to the relationship, it's shredded or destroyed or eliminated of any substantive meaning, so to speak, to be able to be used as an interpretive tool to help identify what is legitimate or illegitimate in terms of acts of the federal government. And so in that sense, this idea of it being a truism and declaratory leaves then open to the Supreme Court the constant ability to then interpret whether a given federal enactment, falls within an enumerated power or within sort of broadly read enumerated powers or not. And that becomes in the eye of the beholder based on other portions of the Constitution as opposed to the 10th Amendment. So from Darby in 1941, which is critical, we can go to the more modern era. And we're going to walk through a whole series of cases now that really take us from the 1970s up until today. And we're going to start with 1976 and the case of the National League of Cities versus usury. And this is reported at 426 U.S. 833. It's 1976 again. And this involves, again, Fair Labor Standard Acts, federal law, that extended minimum wage protections to all state and municipal employees. And so these amendments to the FLSA, placed minimum wage standards and whatnot on state and local governments, so that they too had to comply with federal minimum wage laws or maximum hour laws and the like. A variety of states then challenged the law, the federal law, as interfering with really the traditional employer-employee relationship that the municipal or state government had with its people, and argued that fundamentally this exceeded Congress's powers under the Commerce Clause. And although the court recognized that the Commerce Clause authorized minimum wage laws covering most employees, the court held that the Constitution's structure and the 10th Amendment's recognition of the role of the states in this federal state structure prohibited the federal government from telling states what they must pay their own employees. Super important sort of decision of the time, of course. And here's a quote. "This court has never doubted that there are limits upon the power of Congress to override state sovereignty, even when exercising its otherwise plenary powers to tax or regulate commerce. While the 10th Amendment has been characterized as a truism, it is not without significance. The amendment expressly declares that the constitutional policy that Congress may not exercise power in a fashion that impairs the state's integrity or their ability to function effectively in a federal system." And so this federal law was struck down, and the 10th Amendment then is seen as a bulwark against overexpansive interpretation of the enumerated Commerce Clause power. And so this is a massive states' right win in the federalism battle. And what you also see then in that quote is a very, very important idea, which is that it's more than just a truism. And what the Supreme Court is saying in this decision in usury is that while it's a truism, that doesn't mean it lacks significance. And it is policy reflective of the idea that, states' integrity and the state's ability to function cannot be abridged. And so that actually breathes some substantive life into the idea of the 10th Amendment as being a little bit more than a truism with that language, because that language gives you territory to define states' rights on, right? But the usury case was short-lived because, as we will see in 1985, it was fully reversed. And this is a case that involves a reversal of usury by, at the end of the day, the switch of one justice, Justice Blackmun. And we'll look at that shortly. But let's take a look at the case real quick. Garcia versus San Antonio Metropolitan Transit Authority, 469 U.S. 528 in 1985. And here we had the issue of whether now the transit authority was getting federal funds, whether it was immune from the minimum wage hours rules. And the district court held that transit's a traditional state function, and so it's immune, and so the federal law can't be applied. You've got to follow usury. Case gets up to the Supreme Court, and Justice Blackmun now switches, and his switch is the one vote that switches 5-4 the other way now, and basically said that this traditional government functions idea is unworkable, and ultimately then concluded that the FLSA doesn't damage state sovereignty. And there's a powerful dissent now, obviously, arguing the other side, that says, despite some genuflecting in the court's opinion to the concept of federalism, today's decision effectively reduces the 10th Amendment to meaningless rhetoric when Congress acts pursuant to the Commerce Clause. In our federal system, the states have a major role that cannot be preempted by the national government. As contemporaneous writings and the debates of the ratifying conventions make clear, the state's ratification of the Constitution was predicated on this understanding of federalism. Indeed, the 10th Amendment was adopted specifically to ensure that the important role promised the states by the proponents of the Constitution was realized. And so what the dissent is arguing in Garcia is that the 10th Amendment has now been reduced to a meaningless aphorism, or just a truism that doesn't do anything, and it's been deprived of sort of substantive breathing room and meaning. But nonetheless, that's what happened in Garcia, and the shift from usury was massive and significant. And what's really fascinating, let's take a look at on our next slide here at an interview with Justice Blackmun on his switch. And this is Bill Moyers interviewing Justice Blackmun some years ago. And you can watch the whole video. You can find it online on YouTube. It's really a fascinating video if you're just a constitutional Supreme Court nerd and you like learning about the justices and whatnot. But it's incredibly candid. And so I have it here, and it's worth us reading just to understand, because it shows how significant these federalism decisions are and how hard they are for the justices and how much is on the line and how people can change their minds and have massive consequences. So here's Bill Moyers. What you're saying is that the 6,000 or 7,000 words in there, the Constitution that is, leaves a lot of ambiguity and uncertainty, and that trying to search for the Constitution is almost a daily affair in the lives of judges to decide what the document that's 200 years old really does mean. Justice Blackmun responds, well, I think that's one of the beauties of the document, is that it's not rigid, and that's why it's lasted for 200 years. It bends, but it's flexible. Bill Moyers, let's just take a couple of cases that you've had to wrestle with. 2 years ago, the court voted 5-4, one vote, he's referring to Blackmun's vote, of course, that federal wage and hour standards could apply to the state and local governments. Now, this overturned a decision of the court in 1976, that's the usury decision, that upheld the states' rights to regulate their own employees. You'd supported usury. You, Harry Blackmun, supported the 1976 states' rights interpretation, but you changed your vote in the second case, and that was enough to change federal law. Can you tell me why you changed your mind? Justice Blackmun, well, of course, I was rather the focus of my concurrence in the first case, which was usury against the National League of Cities. I think if one reads that concurrence, he will sense a certain amount of unease on my part at that time. Bill Moyers, this is 1976, you weren't quite sure? Justice Blackmun, 1976. But I went along with it at that time, and of course, I suspect that when the other case came up, the Garcia against San Antonio Transit System, perhaps by that time I had become a little bit more conscious of and what it was in effect a federal-state controversy as to whether the federal rules should prevail over the state. And of course, I've had a criticism on that. I don't feel that I jumped the gun. I may have changed my mind. Some commentators have said this was a struggle for Blackmun's mind, is what it was, because I was the awing vote in both of them. And the petition for a hearing that was filed in the Garcia cases, I thought was almost slanderous, but that's just my own opinion along this line. But maybe one changes a little bit as he grows. Potter Stewart at one time said that, and this is in a writing in one of his short concurrences, that it's better that wisdom comes late than not at all. And so you can see there, it's remarkably candid by Justice Blackmun on, his shifting perception of federalism and what was sort of the appropriate balance and what wasn't in that 9-year period between Usury and Garcia. Really frank and open. Now it gets us to the modern era, and we're going to go to 1992 and New York versus United States. This case addressed a provision of the Federal Radioactive Waste Policy Act. Now, this federal law required states failing to develop adequate plans for disposing of waste generated within their borders to take title to that waste at the request of the owner or generator of the waste. And so this decision, reported at 505 U.S. 144, then gets litigated. And in ascertaining whether any of the challenged provisions overstep the boundary between federal and state power, the court had to determine whether this federal enactment saying that you, the state, must now become title owner to this waste, whether that's authorized by any affirmative grant to Congress within the Commerce and Spending Clauses, or whether instead you're actually invading the province of state sovereignty reserved by the 10th Amendment. And so this take title declaration of federal law, forcing the states to own waste if they didn't come up with a plan to dispose of it, the court found that the take title provision effectively commandeered the legislative processes of states, forcing the states to enact, in other words, state legal regimes addressing how to dispose of waste or not dispose of waste. And this commandeering of the legislature is something that the federal government simply cannot constitutionally do. And what New York held is that this tripped the 10th Amendment. Now, what the court also held is that within that Radioactive Waste Policy Act, there were monetary incentives in the federal law. In other words, if you enact state regimes to dispose and manage, come up with protocols and procedures for the management of the disposal of waste, you can get federal incentives, federal money, whatnot. Those were perfectly fine and not inconsistent with the 10th Amendment. It was simply the take title provisions and this idea that you cannot do that. It violates the anti-commandeering concept. Now here's what's important, and this is at page 157 to 158. Although the holding was not, quote, not derived from the text of the 10th Amendment itself. And that's really important, because what it means is the holding of New York isn't that we read the 10th Amendment and distill a substantive rule out of it. But what the court is saying is that the 10th Amendment's presence and existence is more than a truism in some sense, because it confirms that the power of the federal government is genuinely subject to limits that we have to take seriously. And so we have to be cautious how we interpret Commerce Spending Clause powers because of the 10th Amendment. And this is another significant decision in favor now of states' rights in terms of how one looks at the 10th Amendment as being a mere declaration, or is it something that we have to put a little air into and recognize that it's more than just kind of a code or a legend to the Constitution. So from 1992, we're going to fast forward to 1995. And this is United States versus Lopez, 514 U.S. 549 at 1995. And this is a massive decision from 1995 that addressed the Federal Gun-Free School Zone Act as it applied to a 12th grader. And so what happened is this 12th grader goes to school with a gun. That violates the Federal Gun-Free Safety Zone Act. The 12th grader gets indicted under federal law for taking a gun to school. 12th graders, lawyers say, you, Congress, have no power under the Commerce Clause to enact this Gun-Free School Zone Act that could possibly regulate someone's possession of a gun on a school. That's simply outside the bounds of this federal-state balance in terms of your federal regulatory power. This, of course, touches the 10th Amendment again, and you see here on the third bullet point down at page 589 the quote from the case. Our construction of the scope of congressional authority has the additional problem of coming close to turning the 10th Amendment on its head. Our case law could be read to reserve to the United States all powers not expressly prohibited by the Constitution. Taken together, these fundamental textual problems should, at the very least, convince us that substantial effects tests should be re-examined. In other words, we need to rein in what we've been doing on Commerce Clause, because the Commerce Clause power had reached the point that if anything arguably had an effect on commerce, then it was within Congress's power, and this is rendering the 10th Amendment meaningless, in other words. And so what the court then held on the fourth bullet point is that this Section 922, which is the provision under which this kid was indicted, is a criminal statute that by its terms has nothing to do with commerce or any sort of economic enterprise, however broadly you may define those terms. The government argues that possession of a firearm in a school zone may result in violent crime, and that violent crime can be expected to affect the functioning of the national economy. So that's the argument for interstate commerce that the government's pressing, but as the court held. If we were to accept the government's arguments, we are hard-pressed to posit any activity by an individual that Congress is without power to regulate. In other words, if it's true that you have this ability to sort of build, step upon step upon step, then everything affects commerce. I mean, Congress could regulate sneezing, in other words, because, it would, to sneeze, I may need a Kleenex, and to get a Kleenex, I have to go to the grocery store, and Kleenexes are shipped in commerce, and so now there could be a federal anti-sneezing law, in other words, or some such absurdity. And so this is now a massive holding where the Commerce Clause power was reined in the first significant decision really since the 1930s that had drawn a limit on Congress's ability to regulate under the Commerce Clause power. And this interpretation that's narrowing the Commerce Clause power is done by reference to the 10th Amendment and making clear that the 10th Amendment imposes limits. And that 10th Amendment then has meaning. And so now we have another decision in our federalism battle that Justice O'Connor talked about in the beginning. And the 10th Amendment is, the key chip in the federalism battle on the playing field. Here we have a 1995 decision that is a win, in essence, for the states in terms of it imposing limits on the reach of the federal government's power to regulate. Now we go to 97. Prins versus United States, 521 U.S. 898. And this is a federal Brady Act, another gun case. And under the Brady Act, it required that chief state law enforcement officers had to run background checks on people buying guns. And we can listen right here for 2 minutes to a fantastic clip from the oral argument in the case, that's being pressed. So go ahead and listen to it.
Basic question. Do you think the 10th Amendment has different meaning depending on what affirmative exercise, what power of Congress it is relying on, whether it's the Commerce Clause, the War Power Clause, the Spending Clause? Does the 10th Amendment vary in its meaning depending on the clause?
It may, Justice Stevens, with respect to the Civil War amendments, which I think, as the Chief Justice has noted, were designed as a limit on it. I do not think it otherwise varies, except that it is important not to wholly disentangle these issues. This is so fully within Congress's commerce power because at the time of the Constitution, handguns were made locally by craftsmen and available only locally. It is due in significant measure to commerce among the states and the extraordinary mobility of handguns that guns made anywhere are now available everywhere that roads or waterways or airports can reach. And it was to mitigate the harm of that cheap national availability that Congress tried to take steps in '68 to prevent those guns from being sold to persons who were convicted felons. And
what Congress has done here is to say local police officers are available throughout the country also, and therefore we can regulate.
Justice Kennedy, I think it is significant that it's not merely their availability, but the fact that they were uniquely well situated. The frustration is that a gun dealer who is forbidden to sell a gun to a convicted felon but doesn't know who they are. He gets a form that they check off that says they're not convicted felons. The information that this individual may be a convicted felon is right there in the same town. It may be a few blocks away in the office of the local law enforcement chief. So in the 5 years before we get this national system online, which will itself not contain all of the categories of 922G, it's a rough and ready way to get the most readily available information with minimal efforts to check reasonable records. Makes all the sense in the world in this interim period. Why not wait until there's a national system with these records available at the gun dealer's desk? The answer is that there are 13,000 handgun murders a year in this country, and half of them are crime.
It's often inefficient, is all that you're saying. I mean, yeah.
Sometimes
that's why not many countries in the world have it.
Sometimes
it's a lot easier to do everything, by command.
Sometimes the solution to a serious problem can't be reconciled with the requirements of the Constitution.
Really fun portion to listen to. As you can see, the battle that's going on federalism. And so what the court found is that Congress had unconstitutionally intruded upon state sovereignty. And it rejected the federal government's argument that it could coercively enlist states in enforcing the federal law. And what the quote is that although the states surrendered many of their powers to the new federal government, they retain a residuary and inviolable sovereignty that's reflected throughout the Constitution's text. The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers or political subdivisions to administer and enforce a federal program. These are simply incompatible with our constitutional system of dual sovereignty. And Justice O'Connor in her concurrence notes that the Brady Act violates the 10th Amendment. And so here we have, again, the 10th Amendment popping up as we have this federalism battle. And substantively, Justice O'Connor says in her concurrence, being violated to the extent that states are being forced and local law enforcement officers are being forced to engage in these behaviors at the demand of the federal government. So again, we have another sort of, in our federalism battle, a pushback and a curtailment of federal law. This brings us to the year 2000, and we have the Violence Against Women Act case of United States versus Morrison at 529 U.S. 598 2000. And in this case, we have plaintiff who files a civil action for rape under the federal VAWA provisions for gender-motivated violence. And the defendants who were sued claimed that the statute was unconstitutional as exceeding Congress's power and tripping over the 10th Amendment. Now, the opinion doesn't expressly mention the 10th Amendment, but it did hold that VAWA was not within the Commerce Clause power because gender-motivated crimes are not economic activity within the concept of the Commerce Clause power. And so this picks up on the Lopez decision, which did reference the 10th Amendment, as another example of a limitation in terms of how far Congress can reach in its regulatory power in the name of commerce. And here again, we see the discussion about commerce and its reaches, which necessarily touches the 10th Amendment. As against the argument that aggregate effects of violence touch commerce, and that's the argument posited by the state, like in the Lopez case we saw. This is what the Supreme Court said. Moreover, such reasoning will not limit Congress to regulating violence, but may be applied equally as well to family law and other areas of state regulation, since the aggregate effect of marriage, divorce, child rearing on the national economy is undoubtedly significant. The Constitution requires a distinction between what is truly national and what is truly local. And there is no better example of the police power, which the founders undeniably left reposed in the states and denied the central government, than the suppression of violent crime and the vindication of its victims. Congress, therefore, may not regulate non-economic, violent criminal conduct based solely on the conduct's aggregate effect on interstate commerce. And so again, this is, in essence, another federalism battle case that imposes limits on the reach of the federal government and respects the fact that the 10th Amendment declares that these types of general police powers belong to the states. Now we get to the year 2018, and we're going to look at Murphy versus the NCAA. This is reported at 138 Supreme Court 1461. and this addresses the Federal Professional and Amateur Sports Protection Act, PASPA. This Professional and Amateur Sports Protection Act made it illegal for states or subdivisions of states, municipalities, cities, towns, and the like, to have sports gambling. Now, it did not make sports gambling a federal crime. It just simply said you, the states, can't do sports gambling. New Jersey decided to adopt a state law to have sports gambling. This law then gets challenged. We have litigation, and it reaches the Supreme Court of the United States. And here's what the Supreme Court of the United States holds. As the 10th Amendment confirms, all legislative power not conferred on Congress by the Constitution is reserved to the states. Absent from the list of conferred powers is the power to issue direct orders to the governments of the states. The anti-commandeering doctrine that emerged in New York versus U.S. and Prince versus U.S. simply represents the recognition of this limitation. That's at page 1466 to 1467. And so here we see in 2018 the 10th Amendment again being cited in terms of the interpretive nature of the analysis for the proposition that it's more than just a truism and that it's an important directive and command that requires us to look at the conferred powers and have limits drawn on those conferred powers. And so what the Supreme Court then in Murphy versus NCAA held is that PASPA's prohibition on state authorization of sports gambling violated this anti-commandeering doctrine, and this federal law fails the test. That's 2018. Let's do a little sidebar now in terms of our incorporation doctrine issue. And if you've been running through our other Curious Lawyer Bill of Rights programs, you will have seen by now, as we take each amendment head on, we always ask the question, has it been incorporated by way of the 14th Amendment? If this is the first program you're watching because you're going out of order, let's start in the beginning with what is incorporation. The idea of the incorporation doctrine starts from the premise, of course, that the Bill of Rights in the first 10 amendments applied only to the federal government at the founding. And so the question that then is raised is, when the Civil War amendments were adopted, particularly the 14th Amendment and its due process clause that applied to the states, did the protections of the constitutional amendments in the Bill of Rights then apply to the states by way of the 14th Amendment? And this is called the incorporation doctrine. In other words, does the 14th Amendment's due process clause and the 14th Amendment's prohibition on states incorporate the first 10 amendments and then make the first 10 amendments now applicable to the states, whereas they weren't before the Civil War, post-Civil War, are they? And the answer is they are if a test is met. And here's the basic test. Fundamental rights rooted in the tradition and conscience of our people, and thus implicit in the concept of ordered liberty, are applied to the states via the 14th Amendment. And that comes from the Griswold versus Connecticut case at 381 U.S. at 499. Of course, Griswold versus Connecticut is one of the significant Warren-era court cases, as you will have seen in some of our other Bill of Rights programs here, as we looked at some of the other amendments dealing with the right to contraception and the ability of the state to issue laws limiting contraception access and the like. In any event, what's happened is that based on that test, we then figure out, are these rights at issue in these amendments deeply rooted in the tradition and conscience of our people? Are they implicit in the concept of ordered liberty? If the answer is yes, they get incorporated. If the answer is no, they don't. Now, when it comes to the 10th Amendment, it's a bit of a mind-bending riddle almost. It's never been incorporated, and it seems unlikely to be incorporated because on its face, it's addressing really the balance between federal and state law. And so it's hard to imagine how one could incorporate it and apply it to the state. I mean, it's arguably logically impossible to even contemplate, although I suppose one could concoct very complicated hypotheticals where you may have, national federal laws where the states are now being conscripted to make people participate in some federal regime. And so then the question could be raised about whether this could be used to limit the power of the federal government to do that. But other than mind-bendingly confusing hypotheticals like that, it seems almost impossible, and it has not been incorporated. This brings us to our next slide, and since this is our 10th Amendment and our last program in our Bill of Rights program, I'm going to do a little recap for you on all of our amendments, just so we can remember, because you never know when you're playing Trivial Pursuit or when you're at a cocktail party and someone's going to ask you and you want to be able to say that you, the curious lawyer, know the answer to the question. Which of the amendments have been incorporated, which haven't, which is unknown. So, which amendments have been fully incorporated? The 1st, the 2nd, the 4th, and the 8th. Which have not? The 3rd, the 7th, the 9th, and the 10th. And which have partially been incorporated? The 5th, everything's been incorporated except the grand jury indictment requirement. And on the 6th, everything's been incorporated except that one little sliver of the jury coming from the state or the district in which the crime is committed. So in essence, almost all the amendments have been fully incorporated at root. The 1st, the 2nd, the 4th, the 8th, the 5th, and the 6th, but for minor slivers that don't even really apply to the states anyway, so it wouldn't make sense to incorporate them. They've all fundamentally been incorporated. And the ones that haven't are very, very limited, the 3rd, the 7th, the 9th, and the 10th. And that's the quick recap for you on the incorporation by reference doctrine. Now we're going to talk quickly about pandemics in the 10th Amendment. Gibbons versus Ogden, 1824, it noted that the states had the power to impose isolation and quarantine rules on people. And so there were quarantine rules. Quote, they form a portion of that immense mass of legislation which embraces everything within the territory of a state not surrendered to the general government. So here you have an early pandemic type case talking and noting about when we're dealing with pandemics and legislation dealing with quarantines, that belongs to the states. 1902, we've got this Louisiana State Board of Health case that upheld a Louisiana state law that prohibited healthy people from going to an area where that was heavily populated by people with contagion, such as then the Port of New Orleans. Here's the quote. That from an early day, the power of the states to enact and enforce quarantine laws for the safety and the protection of the health of their inhabitants has been recognized by Congress is beyond question. That until Congress has exercised its power on the subject, such state quarantine laws for the purpose of preventing, eradicating, or controlling contagions or diseases are not repugnant to the Constitution of the United States, although their operation affects interstate commerce. 1905, Jacobson held that states' compulsory vaccination laws were part of the 10th Amendment area of states' rights. So this brings us to our pandemic in our generation. We got one. 2020. Here's a quick little video clip of President Trump at a news conference. Let's watch this first.
Well, you can do a national lockdown. Hopefully, we're not going to need that. We think of everything. I mean, we have every idea that you mentioned we've thought of, and, it's a very big step. That's a step that, in one sense would work. It's a very big step. It's something we talk about, but we haven't decided to do that. Please, go ahead.
Mr. President, what would be the determining factors for you to take that action?
It would have to get to a level. I just don't think it's going to be an action that we're going to take. I don't think I'll talk. But Anthony, all of the people standing behind me would get together in a room, plus some additionals, and we would make a decision. But I don't think that's a step that we're going to be taking.
And now let's watch this second clip of President Trump speaking at a news conference. Again.
Mr. President, just to clarify your understanding of your authority vis-a-vis governors, just to be very specific. For instance, if a governor issued a stay-at-home order...
When you say my authority, the president's authority, not mine, because it's not me. This is when somebody's the president of the United States, the authority is total. And that's the way it's got to be. They can't do anything without the approval of the President of the United States. Go ahead, please.
So if some states refuse to reopen and you order them to, the 10th Amendment of the Constitution says all powers that don't reside in the President of the Congress reside in the states. How do you overcome that?
Well, if some states refuse to open, I would like to see that person run for election.
The key point, when somebody is the President of the United States, the authority is total. And here's the fascinating question that's raised that our pandemic was starting to prompt. It was prompting a 10th Amendment question. We didn't know it even as lawyers living through it, but these battles that were going on were actually 10th Amendment battles. And the question is, could President Trump have issued a national lockdown of all people, total shutdown? He claimed his authority was total, but could he have done it? Could the national government have done it? And the answer to that question turns on the 10th Amendment. And when you look at the history of these cases we looked at that unequivocally put the idea of local police power dealing with contagions in their areas within the province of the state, even though this stuff could affect commerce, the answer is that if he had issued such a brutal national lockdown order, it would have been subjected to massive litigation with big 10th Amendment questions. I mean, it's hard to imagine how the national government could issue a national lockdown order at some level in terms of restricting us from going out of our homes. It may be locking down ports of entry and national ports, could well be part of commerce, but it would have been a massive 10th Amendment battle that we would have been litigating, and it would have all been citing to those 3 cases you see there on the screen. Luckily, we never reached the point of having to figure out if the President of the President of the United States has total authority or not on that area, and hopefully we do not have another pandemic, at least in our lifetime or that of our children or grandchildren. This brings us to our conclusions today. Most importantly, the 10th Amendment is not a pure substantive test that lets us go read the 10th Amendment to then somehow analyze by way of a 10th Amendment methodology whether something is lawful or unlawful. But its presence is critically important, and it rests heavily as expressing this federalism statement, and so it undergirds many decisions. And it's this idea of a truism. Now, on the light end of it, if you want to give expansive power to the federal government, it's just kind of a truism. And if you want to breathe more life into the 10th Amendment, as you saw in the decisions we looked at, it is said to be more than just a declaration, and it has to have some meaning, and it forces us to take a hard look at those federal powers, even if the 10th Amendment itself isn't methodologically used as an interpretive tool to figure out whether the law is lawful or not. But it is, most importantly, the most express statement that we have of federalism in terms of our Constitution. It is really the subject of this federalism balance that we saw across all these Supreme Court cases shifting over time, where we're trying to figure out whether Congress has gone too far or not. And the 10th Amendment's in the middle of all of it. And this federalism shift over time that we see, from striking down New Deal legislation of the federal government to enforcing federal legislation, to expansively enforcing all manner of federal legislation, no matter what, to then curtailing from 1995 until today more and more federal legislation. It's all with the 10th Amendment being front and center in the decision in terms of being an important poll star analytically. And we saw, fascinatingly, even shifting sands decisions for one justice, Justice Blackmun, within his tenure on the court on the exact same question. And so where I leave you today as we go into 2023 and later is with big questions. We have a massive new makeup at the Supreme Court of new justices in the last few years, of course. And so one of the questions that this raises, again, is will the 10th Amendment again feature prominently in decisions curtailing federal reach? And will it take on more and more of a substantive role and home, or will it continue to be treated by some as just simply a stated truism? Time will tell, but I think it probably is going to have more life breathed into it, and it will be cited more frequently. And so you, the curious lawyer, will now know everything you need to know about the 10th Amendment, and when you read these new federalism decisions, you'll be ready. Thank you very much.